Louisiana Lawsuit Abuse Watch is a nonprofit, nonpartisan watchdog group, and our goal is to really promote transparency in our legal environment here in the state of Louisiana. We're known for being a very litigious state, so we want to shine a light on that and do our best to put an end to lawsuit abuses and to encourage the public to become involved and make sure that, that everyone knows their rights as a consumer when it comes to the law. Today we're holding a luncheon for some small business owners from the Acadiana area, and we're talking to them about lawsuits that target the Americans with Disabilities Act. The ADA certainly is a very important law that was created at the federal level to ensure that our friends and neighbors who have disabilities have access to public places. So it's a very, very important and well-intentioned law. Unfortunately, what we've seen are that some trial attorneys have taken this law as an opportunity to extort funds from small business owners who may be slightly off compliance with very minor issues for things like, say, having a mirror that is an inch or so too high or too low, or maybe a handicap parking space where the paint has become faded over time. And then they actually bring these types of issues to a lawsuit. And many times it's without ever even notifying the business owner in advance, so that they really don't have an opportunity to correct the issue before legal action is brought forth. So what we want to do is make sure that folks understand who are small business owners, and we're hosting the event in partnership with the NFIB, the National Federation for Independent Business, and we have some of their members here today as well. So we want to make sure that they understand the implications of these types of lawsuits to their businesses.
So small business owners, you know, they operate on a slim margin. They have a number of rules and regulations and laws and things to, you know, comply with, and so they're constantly, you know, kind of opening themselves to risk just by being a small business owner. And so ADA lawsuits, you know, what's concerning for our members is that folks can just kind of drive by, put these, you know, form letter type lawsuits out against them without any warning, and pretty much demand a settlement and then not really be able to follow through with it. So it's hard for a small business owner to really be able to predict something like that. So a lawsuit, any type of frivolous lawsuit that comes at a small business owner out of nowhere, can really put one out of business overnight. So we have a real concern with programs like this that are happening where it seems to be a coordinated effort, and, you know, we have no way to fight against it. So we're trying to let legislators and small business owners know, you know, what the pitfalls are and be aware, and so that they can avoid situations like this.
Problem is that there are these serial lawsuits that are being filed over disabilities, and they're being filed in group actions by some lawyers from out of state. Typically, the object is attorney's fees, and we need employers to make sure that they're complying with the law before those sort of things happen.
We've had rankings where Louisiana was ranked one of the worst judicial environments in Louisiana because of lawsuit abuse. Now, in order to have a good environment, you have to have a balance in everything. And your judicial system has to be well balanced, and you have to have an environment in Louisiana that says we're open for business here in Louisiana. And you got to encourage out-of-state investments. You got to encourage your citizens on the local level to want to start up a small business, because small business is the backbone of America, and it's also the backbone of our tax base. But how can a small business owner that saved all those pennies all those years and want to start up and take his life savings to try and start a new business survive in Louisiana with a litigation environment as it is? That guy doesn't have a chance. The only people that have chances are these large corporations that have millions and millions of dollars. But what about the everyday small business owner that just wants to make a living for it and raise his family and follow the American dream? And if we want to provide that American dream for him and to give him the ability to actually be successful, we need an environment in Louisiana where he doesn't have to worry about being shut down because of frivolous lawsuits or a litigation environment that's one of the worst in the nation. We want to say, yes, we want you to prosper. We want you to invest in Louisiana. We want you to pay taxes in Louisiana. But we also want you to be a good corporate citizen. And it's about balancing our judicial system and making sure that we are still attractive for those who want to invest in Louisiana. And we can be prosperous, but we have to work on our policies on the state level and create a better business environment here in Louisiana.
It really all comes down to jobs and to economic impact. So even the impact of even one suit against a small mom and pop business could be enough to actually cause them to go out of business. The cost of either settling the lawsuit out of court, which seems to be the goal of a lot of these attorneys who file these suits, or having to go to trial, the money that's involved in either one of those two scenarios is really enough to just break the bank for many small businesses, unfortunately.
If you have a small business owner who has to go and assess the situation based on, a piece of paper that says, oh, you have this deficiency and that deficiency, and you need to fix all that. Well, if a small business owner is already operating on a thin margin and things are not going well in the business, and then they get slapped with $50,000 worth of, repairs they need to do in a short time to do them in, that could put them out of business. And so our small business owners don't want to have that, because that ends up affecting jobs. Their employees are going to be at risk. And so that's not really what we want to see happen in the long run.
A lot of the banks have been impacted over the last couple of years. So have the hotels. So have just about every organization you can think of, because there's some sort of item that someone believes they should provide to people who say they're disabled. So we're talking about comfort dogs. We're talking about swimming pool lift items. We're talking about websites, and that's happened to a number of employers. They had to go through a demand from a law firm, and then we had to defend against that. A lot of times we get it dismissed right away. Sometimes we have to deal with it, and still it depends on how much the cost is to provide the accommodation.
Thank y'all for taking the time out of your days to come and just learn a little bit about ADA lawsuits and kind of what's kind of happening with them. And for us, for NFIB, we represent 4,000 members across the state of Louisiana and 325,000 across the country. And many of you in this room are our members, and so we thank you for that. And we want you to share the good word that you're learning here with your other small business owners that you're familiar with, to let them know and be aware of these things. It is a federal law, so unfortunately these guys in the room can't help us, but I did want to take a minute and Representative Kusan, Representative Stefanski, and Representative Frivolous, thank you for coming and for the great work you do at the Capitol for us. Yeah, these guys you're lucky to have these guys representing you, and you're here in this area. And so, it's important to have good legislators who understand the issues, and that's why we invite them out to things like this. Unfortunately, like I said, at the federal level, the ADA is what it is, and Congress has been working to kind of do some different things to tweak it to protect business owners better and protect the people the law was actually designed to protect, which are people with disabilities, so that it isn't being taken advantage of. But at this point, there's still a lot of work to do. And so, we looked at maybe talking about doing something at the state level to do something with the ADA, but there's really not a lot, again, with it being a federal law, that we can do here. So anyway, so knowledge is power, though. And so we, we hopefully will impart a little bit of wisdom to everybody today. So I'll turn it over to Lana and let her say a few words. Lana is the new director of the Louisiana Lawsuit Abuse Watch Group. She just came on board. She was with ExxonMobil for years, and so we're excited to be working with her. I work very closely on tort reform issues with the Lawsuit Abuse Group, because small business is all about lawsuit reform and getting things changed so that you folks here are not constantly at risk.
Okay, good morning, everybody. Again, thank you for coming out today, and thank you, Dawn, for the introduction. We're really excited to partner with organizations like NFIB and your members. We know how important it is for us to change the lawsuit climate in Louisiana. Unfortunately, Louisiana has long been known as one of the most litigious states in the country, and that is something that we want to change. So law, as we call Louisiana Lawsuit Abuse Watch, is really dedicated to trying to do what we can to make those changes. And what we refer to as tort reform or civil justice reform was really what we're talking about. So we actually are a 501c4 organization. We are a grassroots organization. We don't lobby directly, but we do work with our policymakers, with business owners, with citizens across the state, just to make sure that everyone is aware of the challenges that we have with our current system when it comes to the civil justice system and the things that we need to do to improve. So that's what we're constantly working to do. Education, you'll see hopefully a lot of media push from us. I had the opportunity to do a radio interview yesterday on KPEL talking about the ADA specific issue. So hopefully we'll be able to continue to get the word out, and you guys can also help us do that as well, because there's nobody that can speak more effectively to the situation that we're in the state than the people sitting around this room. When we talk about ADA lawsuits, I mean, who is at risk? Well, it's pretty much everybody. I mean, we're right here where we're sitting, Rufino's. I was thinking when we walked in this morning, Fred and Jerry back there and I were the first folks here, and I noticed they had just mopped the floors. And I was thinking, well, better be extra careful. You know, there are so many little things that I don't think people really think about necessarily, but bars are certainly a target, retail establishments galore, shopping centers. We've seen state government agencies be targeted a lot of late, pharmacies, shopping malls, and then even lately online, internet-based and app-based businesses and organizations are being targeted. And I know Fred, our guest speaker, is going to talk a lot more about that, so I'll leave him to that. But this is just an example how really abuse of the Americans with Disabilities Act lawsuits can really impact just about everyone. Okay, and just as another illustration, before I turn things over to Fred here, you can see from research that we did, that law did, pulling from court records filed in federal court. I think the most interesting thing to note here is that between 2014 and 2015, there was a 37% increase in the number of lawsuits focusing on the Americans with Disabilities Act in Louisiana. So that is significant. So what we're finding, unfortunately, is that a lot of folks who may not ever intend to do business with a business or at a business are looking for opportunities, and unfortunately there are a lot of plaintiffs' attorneys who are very happy to take those opportunities and move them forward and turn them into litigation against those businesses. And that's something that we really want to stop. We want to make sure that our business owners have the opportunity to operate, obviously under the law, but we want to make sure that you guys, if there is any sort of infraction, that you have an opportunity to address it before it gets taken to this level. So clearly we do have an issue with this in Louisiana. It's one of the many types of lawsuit abuses that we face here. So again, thank you for being here today, and I'm going to turn it over to the expert here who's going to tell us a lot more detail from his vast experience in dealing with a lot of these lawsuits. Fred?
Let me talk a little bit about what the disability, we're going to talk about what's the Disability Act, how's it being abused, and what steps can you take to reduce that risk. So first, Disabilities Act. The Americans with Disabilities Act is a 1990 law. So it's been around for almost 30 years. It was signed into law by the second President Bush, who also made a lot of speeches about it, and there's a lot of legislative history about it as well. What does it do, and what does it provide? Well, first of all, as you'll see in a minute, one of the reasons it gets abused is because it provides, if any sort of win on this, provides attorney's fees. Now, it is the second most filed lawsuit in federal court. Well, anybody know what number one is? I've talked about this more ad infinitum. Wage and hour. It's Fair Labor Standards Act. It's minimum wage, overtime, all that sort of thing that everybody's bugged with, which was a big issue 2 years ago when the Obama administration was about to raise the white-collar exemption from $23,660 to $47,476. But it is the second highest filed lawsuit, so it's important, and usually in federal court. The people that file lawsuits don't have to warn you. They don't have to tell you it's coming. They just write you a demand letter, and it's a little bit like malware. God, I hope you never have that. I hope nobody ever seizes all of your computer intranet and all your information, and then tries to ransom it back to you. But it's a little like that, where you just a lot of times you get a letter, and I'll talk about this a little bit. We've been through a lot of these, and they tell you what they're going to sue you for. They suggest a settlement. They typically leave the amount out because they're negotiating with individual employers to see how much they can get from each one, and they're asking for some attorney's fees on top of that. And then, you know, if you're a smaller employer, you're saying, okay, what's it going to cost me to defend and do all the things that maybe some court might tell me to do versus paying them some money.
What's an average cost of defense?
You know, it could be $5,000 to $10,000 easy. Depends on whether it goes to court, you know, whether it's tried and all that. And it's a substantial, and it's not just that. It is that I think there's a lot of concern about what's going to be required to be done. And we're going to talk about that in just a minute. What's required and what people have to do. Hi. Welcome. So, there's three parts of this law. We call it Title 1, 2, and 3. We're going to talk more about Title 3. Title 1 is the employment part for those that have employees, 15 or more employees. Disability is another kind of discrimination that is prohibited. So just like acting against somebody because of their race, their age, their religion, disability, but disability is a little different. When that law was passed, I don't think, well, the Exxon people are government contractors, and I don't think anybody else in here, government contractor, has an affirmative action plan? That's about the only place you have to, that and religious discrimination, where you have to step forward and actually try to accommodate somebody, make it easier for them to work. This is one of those places where you do that. We borrowed, I'm a little bit of a historian when it comes to this. You know, I think you got to know where you've been so you know where you're going. So where you came up with this accommodation piece is from the religious discrimination part. Religious discrimination requires that you try to accommodate somebody's sincerely held religious beliefs if you can, without undue burden. This is pretty much the same, and we borrowed it from that from 1964 to 1990. So now we have this. And so Title I, like I said, is employment, and we'll talk a little bit about that. Title III, which is the one where, that Dawn was describing and Lana was explaining, is the one that has to do with property. The one that has to do with property and premises. So we're going to talk a little bit more about that in just a minute. Back when this law was passed, it was predicted that 18% of the United States population was disabled. And I'm thinking, 18, that can't be. You're telling me 18% of the people in the United States roll around in wheelchairs, can't see, can't speak. And so when you find out how broad this law is, you'll see why that's not true. And I will bet you that every single person in this room can qualify for a disability. I guarantee you can. In the day of drugs, and I'm talking about legal drugs, and I'm not talking about abusing opioids. I'm talking about day of drugs where people, for the good, are taking one thing or another because of some illness or perceived problem. Everybody's got some sort of disability, and it's a very broad term. So we're going to talk about what that is in just a minute. And it's broad when it comes to either one of these, whether it's employment or whether it's trying to accommodate property. So let me take that up now and tell you how that's construed. And like I like to talk in terms of outlines. I'm not trying to speak down to you, just my feeble mind thinks that way. And when I teach a couple of courses at one of the law school, and then I'm teaching at UNO, and the kids, you try to confuse the kids a little bit so you can, bring them back to reality. And then, but I'm not going to do that with you. So there are three broad pieces here. First one is, we're talking about what is a disability. So the first one is the major definition is it's an issue that somebody has with a major life force. There's a lot of sort of smoggy, hidden meanings to all these terms of art. So what does that mean? That's really number one, impairment which substantially limits major life activity. It's an impairment, okay? So can't see, can't speak, can't hear, can't walk. Those are things you'd think of right away, right? Those to me are impairments. Those are clearly somebody who's disabled, and in the old days we called it handicapped, right? But now it's disabled, and we call it individuals with disabilities. So that's number one, okay? Now, that's got three subparts under it. Each one of these is chock full of all kinds of definitions. So it's got three subparts. Number one, physically disabled. Number one, impairment, okay? Physically disabled. So that's clear. Those are the ones I just talked about. Can't hear, can't speak, can't see, like that. Number two is any disease. The law was amended in I can't remember the date. I think it was 98 or 99, and it's even broader than it was. To try to prove something's not a disability is difficult, and I'll tell you what some of the things are that aren't disabilities in a minute, but they're few and far between. So, major life activity. So any major life activity, disease, any disease will do it. Cancer, epilepsy, just a panoply of diseases. Any of those will do it. And we used to argue that AIDS was not covered. It clearly is covered. HIV is covered, no doubt about it. All right. The third one under impairment is mental. We're talking somebody that has ADD. The hardest ones of these, we get 2, 3, and I'm telling you, we get some strange calls over the years. I've been doing this for 35 years, and I'm telling you, strange things happen. So somebody claims they have a disability for some odd reason, and it's not something that's run-of-the-mill. It's something that's out there. These days, and it doesn't have anything to do with the property, which we're going to get to in a minute. It's sense. I don't mean S-I-N-C, I mean S-C-E-N-T-S, sense, right? It can be a disability. People who are, I had one 2 days ago. We've got a facility, an office, big corporate office, not in Louisiana, and one of the, I think you can remember things better when you hear stories. We got a new employee and 2 other employees, all 3 are women. 2 of the employees say that this employee has some sort of scent, and they start coughing and wheezing and all this sort of thing. Okay, which you can understand. I mean, if somebody wears some really strong perfume or anything like that, aftershave, sometimes it affects you. They really affected them. We have tried to do everything. We're trying to accommodate, right? Back in the day, they say, oh, just tough it up, you know? No, we're trying to accommodate. So we're moving people around, and this lady, the one that's causing the issue, is very cooperative. She's tried everything. We said, stop wearing whatever you're wearing perfume. Okay? We said, what are you washing your clothes with? And she changed that. And it's still going on. We have now targeted, as of yesterday, we think, this is very strange, there's some smell in her car that is on her. And we've moved her, and when they go in her office, by the way, she's across the way, they still have a problem. So it's more than one person, it's 2. So that's the kind of thing you get from this very broad view of what is a disability, right? Because it can be pretty much anything. Now there's some things.
The disability?
The 2 employees, no, the ones that are affected by the scent.
Okay.
Yeah, because hers is artificial. It's something she can change. Okay? So that's point 1. And by the way, what's not a disability is very, very slim. But I will tell you, current drug use, not a disability. That's why we spend our lives looking at employment policies and changing them and all that sort of thing. And so that is one thing. You can discharge somebody after the first time who is positive for drugs or alcohol. And if you want to talk an hour worth of marijuana, I guess I could do that too. We're dealing with all that all over the state and all over the country. Real interesting. If you're a banker or your MasterCard or one of them, you are absolutely in favor of legalizing and being able to deal with those folks. There's a lot of money in there, and they can't do it. It's unfortunate for them. So, current use of illegal drugs, clearly not protected. Now, former drug user, yes, protected. Okay? How about compulsive gambling? Anybody think that's protected? It's not. It's not. Why? Because in 1990, the casino folks went to Congress and got it exempted. That's why. They didn't want it. Okay? Now, you hear all these advertisements. We do a lot of work in the casino industry, and you hear them doing these advertisements. Of course, they have ATMs sitting right outside the gambling area so you can go get some more money, right? All right. Third thing that's sort of interesting. How about kleptomania? Not covered. Why? The retailers went to Congress, got it exempted. Why? It's not just the retailers. So Johnny Jones is outside. He's getting in his car, and you say, I think Johnny's got some of our stuff in the back of his trunk. He said, Johnny, could you open your trunk? And you open, and there's all your stuff back there. Okay, everything, all your pencils and your papers and your retail stuff and anything else you can think of. And he said, got this little problem. I got a note from my doctor. And he says, Johnny is prone to picking up things that don't belong to him. He's a kleptomaniac. Protected. Can't say it, can't do it, right? So not protected. Very broad. Second category, record of having such an impairment. So you don't have it, but you used to have it. So I'm talking about recovering or recovered cancer victims. I'm talking about what I just said a few minutes ago, somebody who's recovering from a drug habit, alcoholism, things like that. Recovered or recovering. And then you say, there can't be any others. Yeah, there's one other one, perception. Perception, regarded as, we called it. So I'm just showing you how broad this disability law is, that's both property and employment. So they don't appear to be disabled, but I'll give you a couple examples. So Johnny Jones comes back to where he's currently employed. He comes back to work. He broke his leg doing whatever, workers' comp or non-workers' comp at work, whatever. And the supervisor says to him, man, Johnny, you think you're fully recovered. You'll never get over that. You're like Patrick Robinson from the Saints. You're not just going to be out 8 weeks. You're going to be in trouble for the rest of your life. So we regard him as being disabled totally. Okay, not a smart thing to say. And I will tell you another one. Let me make sure nobody has this. I don't want to embarrass anybody. No, none of you have this. It's called ugly. Ugly. Perceived disability. There's at least one case. Where do you think that case is? California, right? Always California. Perceived disability. I would love to see how anybody proves that. How do you? I don't. Well, I'll tell you. I'll tell you exactly. It was somebody who worked in marketing in a retailer, and they claimed that the employer only hired nice-looking men and women, which was true. Okay, which is true. It was definitely true. Okay, it's sort of like when you go into politics. I think I'll hire all my enemies to be my administrators. I don't think so. You know, I mean, that's just what they do in marketing. And they claim, now the hard part about that, by the way, and a little off subject, but I've never known how somebody proves that. How do you prove it? Because there are people who some of us don't think are nice looking, but others do. So back in the day, when the Roman days, there were these people, you know, the attractiveness was somebody being a little bit overweight because they could eat a lot, and they must have been rich, right? So people like short people, tall people, people with different color hair, and nobody really knows what becomes attractive or not. So I don't know how you prove that, but that can be a perceived disability. We have, yes, sir.
What about adult ADHD?
Yes, absolutely. The hard one on the mental, I'll tell you the hardest one. It seems like I've dealt with all these, but probably there's some that I haven't even touched. The hardest one is bipolar. Very, very. So you got Dr. Jekyll and Mr. Hyde. Come to work and they're real nice, and then the next day they say, I'm going to kill everybody here. And by the way, we do a couple hours worth on violence in the workplace. We don't take those things for granted anymore. Everybody knows that, right? I mean, there's actually an Occupational Safety and Health Administration regulation on this, and we represent all the community colleges in the state. We've trained them. We trained some of the parishes, governments. They're prone to this. People get mad and get upset, come to your office, and lawyers, I tell you, the number one group that gets shot at the most are family lawyers. I think labor and employment lawyers like me are like third. The criminal lawyers are second. Family lawyers. Why? Because one of the spouses is mad and they come to the office and shoot them. That's what they do. So those are very difficult to deal with because the law says bipolar is protected, but it doesn't protect somebody for threatening you or shooting at you, and we take those real serious. You should. You should. You've got repeated lawsuits being filed. Lana showed you that. There's a law firm named the Beiser Law Firm. It's filed hundreds of these lawsuits, talking about property lawsuits, and we'll talk about that in a few minutes. There's also a couple other law firms in Louisiana that have been doing the same thing. I saw a couple on the list today. And I was with a client here in Lafayette earlier this morning, a small hotel. He's got about 4 properties here. And we've been through this with him a couple of times, and I'm going to talk about what happened. Won't say his name. And it happens in just about every industry. So let's talk a little bit about some of the things that we've seen and the more popular targets that Lana mentioned a couple of these, but I can give you some experiences. Let's see. And typically the way they happen is you get a letter in the mail, the employer gets a letter, they make a demand, they've got a client, they've designated a client in your area, somebody who can't see, can't speak, can't hear, or something, or can't access. It could be a city, it could be the state, can't access. You don't have a handicap spot. You don't have curbs where they can get up, get the wheelchair up, all those sort of things. And so they make the demand and they send a letter and they want attorney's fees and they want you to make some changes and all that sort of thing. So let me talk a little bit about some of the issues that we've seen and where it comes up. Ingress and egress, meaning entrance and departure. That basically has to do with wheelchairs and people who can't. Now, you've got some really there are two kinds of groups that are covered by this law. One are public accommodations. Dawn mentioned there are like 12 categories, and I think Lana said just about everybody's covered, and that's true. And the second group are the private institutions. Now the private institutions basically don't have to go in and make changes until they do new construction or change something. But everybody else does. But whether you're public, so we're talking warehouses and like that may not have to make the changes. But the law's been passed so long that everybody's been doing changes in their buildings. There are a few exemptions but none of you are probably going to ever be able to use those. Government is exempted from Title III, but there's a whole title covering government. Title II covers government, and they're pretty much covered by all of this, but it's under a different title. Religious organizations, pretty much exempted, except if they open their doors to the outside. So their schools that they've opened up are going to be covered. They're renting out their gymnasium, going to be covered. Same is true of any other private institution. Example is also not just the religious organizations and those, but others who may fit under some political vein as well. So there are a couple of exemptions, but not many. Okay? So pretty much everybody is covered by both of these laws, by both the employment part and the property. But let's talk about the property and what we've seen. So we talked about ingress and egress and wheelchairs and like that. Problem is, a lot of buildings, particularly in older sections of most towns, were not built with elevators, right? I mean, you see a lot of restaurants like that, some hotels like that, some other facilities like that don't have an elevator, you just walk up. Now, these days they're rebuilding that because a lot of people can't access it and are potential customers. The property part of the ADA, the Americans with Disabilities Act, is customers, vendors, anybody in the public who needs to access it to come into your facility. So let's talk about what we've seen in different industries and what happens. Talk about swimming pool access. That's real tough. About about every 2 years we do a guidebook for the hotels and the banks and all that. And so we had just picked that up about 3 years ago. And swimming pool access became an issue. The DOJ, Department of Justice, says you have to have equipment to be able to have disabled people be able to access a swimming pool. Well, it sounds good. I mean, you want that. But here's what happens in the end. So you're a small mom and pop, and you own maybe one hotel, maybe two small hotels. And so just buying this equipment is fairly expensive. But the expense is having somebody trained who can use it. So you've got to have somebody on staff or two people who can use it. And they're going to have to be there if somebody comes in and wants to use it. Now, I will tell you that most of the mom and pops have never had anybody who's disabled who either needed help or needed the machine. I mean, a lot of disabled people have somebody with them who can help them, and it just never happens. But it's an expensive venture. And so if you've seen some of these pools closing, that's why. Some of the mom and pops have closed their pools. They have. Yes, sir.
Question about the staircase. If you have a restaurant who has a second floor, then you can accommodate the person on the first floor. Have you seen lawsuits dealing with that? Hey,
yeah.
I want to sit on the second floor, not the first floor.
Yeah, the rule is, can you reasonably accommodate? So I don't think it always has to be that you have to change the building. I think sometimes if you can put somebody on a ground floor like this, I think you're going to be okay. A lot of times, though, the restaurants don't have those big conference rooms up on the second floor, just like the hotels do. But of course, most of the hotels have elevators. Yeah. All right. Website usage, a big deal, because it's just about everybody. Just about everybody. And what have we seen on this? Well, about 3 years ago, one of these serial plaintiff lawyers, filers from out of state, this one was from Philadelphia, started writing all the banks in Texas, Louisiana, and I think Mississippi or Alabama, and claiming that their websites did not accommodate the disabled. In other words, people who couldn't hear and couldn't see. those are the basic groups. And these people just would love to be our customers or make a loan or put a deposit, something. And they chose people who had one of those disabilities to be their plaintiffs. And they wrote letters, and the letter's like, I don't know, 4 or 5 pages long, and it's got, interesting, they put a settlement agreement at the end of the letter with a blank space for the dollars. I'm not kidding. I'm going to frame it someday. So they wrote to everybody, and the way we dealt with it is basically, well, first of all, there's a real legal question about whether websites have to be accommodated. Although the DOJ, Department of Justice, is probably moving that direction, so that you do have to have it. Those of you that are with large corporate, like an Exxon or some of the hotels that are franchisees and they're using the franchisor, there's no more Starwood, Marriott, Hilton, using their facility, they're accommodating. But if you're a smaller group, you probably don't have a website that's accommodating. So those are the ones they're going after. So they went after pretty much the community banks, when there's a lot of them, of course. So some of them were in the process of converting over, some were not. And in the end, what we ended up doing is, I've thought a lot about this. We combined, going after one facility is one thing, going after everybody is something else. So we combined everybody. Louisiana Bankers Association did a good job with this. And we wrote a letter back to the law firm, basically said, here's what, tell your person, we'd love to have them as a customer. Come on, we will send Uber to get them. We will come get them. We'll piggyback them on our back. We'll whatever it takes, we'll put somebody with them, and we're going to take care of them. And of course, we never heard, okay? And in the end, I mean, the truth is, we do need to accommodate. That's the way the law is moving. So we're probably going to do that. I mean, all of them are doing it. Here's the issue, by the way. And by the way, there was one other thing. Our Attorney General also wrote them a letter telling them what they were doing was violative of a law in Louisiana, and saying if they came to Louisiana, he was going to pursue them, and it was violative of the law, and we never heard from them again, which was a good thing. We avoided a lot of trouble. And at least
professional conduct, you mean?
Yeah, and there were a few other little items that he found as well. There were a few things. So they didn't come back.
How do you accommodate a website to be hearing?
Good question. Here's what you do, and we're doing it, okay? There are, I don't know how many there are in Louisiana, maybe 3 or 4, consultants who will come in and work on your website. And so there's a voice for those who can't see. Like in the elevators now, you've seen the elevators. When you get to the 15th floor, the voice says, 15th floor. It's for the disabled, okay? And for those who can't hear, obviously, or maybe can't see as well, big letters, big print, like that. So there are ways to do this, and you get the consultant in. The problem was that there was so much of this going on a couple of years ago, and I think there's still some going on. They were backed up. And so to get somebody like that would take you a little while. And then it took them 60 to 90 days, I don't know why, to get you up and running.
But if you were blind, I just think navigating the internet in general has to be...
I think you can do it. Some of this can be voice activated. I don't know enough about technology, but I can tell you that there are some ways to do it.
Yeah, I think they have Braille machines. Braille machines.
And we're not talking about just people that are blind, okay? I'm talking about people that can't see very well, because good enough to walk around, but not to drive and do other things like that. I can tell you, we had one at one of the nurse housing for the well-aged, and lady came in. She wanted to do our job, just to show you accommodation. She wanted to do the security job at the front desk, and part of that is we got buku cameras, and you look at the cameras and out on the outskirts and see if anybody's in the parking lot and all that. Well, she really couldn't see. I mean, she was legally blind, although she could see enough, to walk around and all that. So we thought about it, and we said, well, we'll try to accommodate. So we got a magnifier for the cameras. And she came in. We knew she was trying. This was lawsuit waiting to happen. So she came in, and she looked at it, and she was honest. She said, I still can't see it. And that was the end of it, and she couldn't do the job. So we really did try. We really did try. In terms of the website usage, that, I think, is something most employers are accommodating.
And that comes in on the employment side. You can't discriminate based on
Comes in, no, this was a customer.
Oh, it was a customer.
At the bank, yeah, but it's both sides. Both employees. Some employee says, I can't read it. Can you somehow accommodate me? Or this is a property issue. Vendors and customers, that's a property issue. Okay, comes under Title III. Yes, sir.
About rental properties, and not just apartments, but single-family rental properties.
Viewed as not a. It's interesting you mention that. It's viewed as not a public accommodation, but the rental office is a public, so you've got to have that to be able to accommodate anybody that walks in, but the apartments, no.
You don't have to accommodate. Okay,
no.
That's good.
No. Unless, you rebuild, and then you probably do at that point. But the current ones that come before grandfathered, you don't. You don't. And I think the accommodation might be a first floor instead of a second floor, because some of those don't have elevators, obviously, in most apartment complexes. Okay. Let's see. Work-related injury, I'm going to mention real quick because that's more of an employment issue. And tomorrow, LABI is doing a workers' comp thing, and I'm doing 30 minutes on ADA, FMLA, and all that. So anybody's coming, I'll see you, and I'll talk more about that. But bottom line is, there's a lot of plaintiffs' lawyers who are doing workers' comp who will come back and somebody gets discharged or they get issued COBRA, meaning they have to pay for their own group health insurance after a certain amount of time. They'll file some kind of claim. Got to be careful. And leave of absence expiration, too. There's a lot of confusion about when you can discharge somebody, when you can't, under the Disabilities Act. So those are, let me mention one other one that's not on here that I dealt with this morning, and it reminded me of that. Service animals. Service animals. A property issue. Why is it an issue, and what happens? It's an issue because of the misconception. There are two kinds of animals that are under the Disabilities Act, okay? One is a service animal. Now that is an animal that's been trained to deal with the disability. And the others are, for lack of a better name, we call them emotional or comfort animals. I like to have Susie the cat here because when I rub her, I feel a lot better. Okay, and I like my parakeet, and I like my monkey. Yeah, I mean anything, it could be anything. And there is something, if you've ever been on the internet, they even give you a little certificate that you can somehow present to people and say, I need to bring my,
the airline.
Yeah, well, the truth is the airlines have gotten tough about that. They have. And the government is not going to come down on us for that, I don't think. Service animal, yes. Comfort animal, no. It's not covered by the Disabilities Act. It's not. It has to be some animal that's trained to deal with this with some known disability. Now, suppose somebody could say, I have a nervous state and get some doctor to write it, and when my animal's with me, Then you get into a balancing because sometimes these animals, people are they're messy. They bite people. I mean, I've been down this road too many times. They bite and
It falls under the property and
yes, both could be either. Could be somebody brings a dog into your shop, or a hotel, or a restaurant, or a bank, or any place. Could be both. And so, but they're not strictly covered. They're just not. And then you get into a weighing thing about other people being allergic to them as well, and all that sort of thing. But strictly speaking, they're just not covered. That's all. Okay. All right, so let me talk just a minute about what we do to reduce the risk, and that's really what we want to talk about, and then we'll end because I think I'll be about out of time, and we've got 5 minutes maybe left after that. All right, so there are 3 things. Number 1, determining what remedy you can take for any non-compliant premises. So for that, I would suggest that you get your architect, your contractor, or somebody like that to walk the premises and look at it with you, because they'll know some alternative building around. My cousin's we represent ABC and AGC, and my cousin is a contractor. And I said, Harry, you guys were behind this transvestite rule, weren't you? This provide separate bathrooms for transsexuals, all that stuff. I said, you guys just want to build some extra bathrooms. That's all there is to that. But seriously, people like that will know what the alternatives are. They can help you accommodate, and I'd have them walk it just to see what you can do, rather than wait for somebody to come in. I mean, you can sort of look at it yourself and say, gosh, we don't have any handicap parking. We don't have curbs that somebody could wheel up on like that, because those are the ones this Beiser law firm's been going after. Those are mostly, they mostly deal with those.
Cracked sidewalks.
Cracked sidewalks.
Other issues like in New Orleans is sidewalks, you know, that
Good point.
they're having there. But I mean, it's old sidewalks.
And
like
even historic properties that are by nature,
Yep.
historic properties that are hard to repair to code.
Very. The handbook, everybody needs to look at their employee handbook, personnel policies, employment application, making sure that we're not asking questions to employees or others, or even vendors and on the property side and all that sort of thing to violate the law, because we're not supposed to ask them questions about their medical situations. For employees, you ask, can they do the job? For vendors and if somebody brings a service animal in, an animal in, you can absolutely say, what disability and how are they trained? And most of the time, they're not going to know that. They're not going to have it. The one I was dealing with this morning, we had here in Lafayette, we had a group came in for, was it a baseball tournament this weekend? Must have been a baseball, they told me it was a baseball tournament or something. Maybe it was a football tournament. Some tournament was going on. And there was a whole bunch of people in there, and they were out in the parking lot drinking beer, whatever they were doing, and they locked a dog in their room. The dog started barking 11:30 at night. So manager didn't know how to deal with it. He calls the guy that owns 3 or 4 of these hotels, and it was waking everybody up, and so they went out and they did what they called us. We did what we had to do. We said, is that a service animal? You know, it absolutely wasn't. They went in the room, which we're allowed to do at hotels, and the dog damn near bit the help. I mean, the dog was not a nice dog, say the least. Or maybe it was, and it was just rambunctious or something. But yeah, guard dog or something. And let them stay that night, and then transferred them someplace that was more pet friendly than we want to be. So, you know, not really covered. But those things happen in real life. And then third, you want your staff, the supervisors, the managers, to at least know we spend our lives training managers, supervisors over all kinds of stuff. And you need to make sure they know what to look for, because you're going to get a claim, a charge, a lawsuit if you don't deal with it. So, like I said the other night, manager knew enough. We had given him enough information that he knew he wasn't going to be able to handle this, and he called, and you know, we got to it. I mean, if that had been a service animal, a real service animal. By the way, those service animals, in my experience, are very well trained. I don't know if anybody's had any. Yes, they are. And they don't bark a lot, and they don't make a mess, and they really, I mean, they're trained. These are real trained animals. And so you don't have that issue that you do with somebody's little pet Toby or whatever the dog's name is, you know? You don't have that issue most of the time. The dogs are just know what they're doing, and they do it. And mostly it's people who can't see. So, but the others, different story. And just, you know, you've got to deal with that, and we come up with some alternatives and deal with it, okay? Questions? Yes, sir?
Yeah, so I mean, if you get this demand letter and it says, hey, you don't have a ramp,
Mm-hmm.
and you go, okay, build a ramp. And like in that week, call the contractor, comes out and he builds it.
Mm-hmm.
Where is the claim? I mean, after that.
The claim is that you didn't have it when this guy tried to access. Because he hasn't just, typically what they do is they send him out there to try to access. They've gotten past the theoretical things, and I don't think I could access it. No, go out there and see. So he's tried to access it, and he really is disabled in some manner. They're not faking that, and he can't. And so there's some reason for They may not get the injunction; they'll get the attorney's fees.
Because, and then when you go and fix it, you almost admit that there was an issue.
Yeah, but yeah, you know, I've heard that before, and of course, we really don't believe that's an issue, and I'll tell you why. I have this happen all the time I'll give you an example. Drivers, okay, CDLs types who are on the road. We do just about every industry, and they're at the top of the list for this one. So they have an accident, and we drug test them, or we including alcohol, and you just made the case for the other side when they hurt all these people, okay? But that doesn't mean you shouldn't do it and do what's right. You've got to fire that person, or you got to do something to them if they're under the influence. So yeah, you sort of do make their case, but you cut off your liability into the future, so you fix it. Now, not everything's got to be fixed that way, though. I mean, there's some demands that they make sometimes that just are so expensive and so ridiculous, you can't do it because there's a cost benefit balancing test that you look at. So if you are a mom and pop and they ask you to rebuild the entire facility, that's something that is an unreasonable burden. But if they ask you to buy an amplifier for the receptionist, which is $2, okay? I mean, most people could do that, right? So it depends on the kind of accommodation we can try to make.
What's your advice to businesses in Louisiana?
We typically have advised three things. One is to audit your property to determine what else you might have to do to accommodate the disabled. A second item is to go through and revise your personnel policies so that you are making sure that you're in compliance with the Disabilities Act concerning employment and the employment of disabled people and hiring of them. And third is to train the supervisors to notice issues so they can bring them to the owner's attention.
We believe that today has been a really great opportunity for our business owners in the area to really better understand the impacts of these lawsuits that use the Americans with Disabilities Act as an opportunity to gain more clients and to make more money for plaintiffs' attorneys, unfortunately. We've had a really good response today, and we feel like these business owners will take the information back and share it with others in their community. And again, that really goes back to the goal of law, or Louisiana Lawsuit Abuse Watch. We want to make sure that the public and our business owners really understand their rights under the law, and we want to make sure that they're not taken advantage of by others who actually may not have the right motivation. They may not be aimed at righting any wrongs, any minor violations of the ADA. They may just want to have an opportunity to sue.
Well, I think it's positive. I think it's great to let small business owners know about all the things that are, that they're facing, the constant threats to being in business. And we appreciate the folks that are able to come out, learn about these things, and then go out and spread the word.
If people have questions like more information, what should they do?
We have two great resources on social media. We encourage people to follow us on Twitter at Reform Louisiana. That's our Louisiana Lawsuit Abuse Twitter handle. And also we have a Facebook page and a website, lawllaw.org. There's lots of great information there. And we also encourage people to sign up and become part of our law family so that we can share developments as they're happening, and encourage our supporters out there to take action and let their lawmakers and policymakers know how they can help change the tort climate in Louisiana.